Hi, my name is Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're going to continue our video series designed to educate and inform the public, so please subscribe to our channel. I talk to a lot of attorneys and a lot of clients who talk about the situation where there are lies in the divorce papers. It could be in the complaint for divorce. It could be in a motion filed by your ex's attorney alleging that you did this, this, and that, lies, lies, lies. And the question is how best to handle it. I will tell you this. You have to understand one thing. Filing a document in front of your divorce judge or your family law judge is not exactly the same as if it's in the paper. Okay? If somebody prints lies about you in the paper, for all you know, the viewership of that paper might believe those lies. Could be very, very damaging to your reputation. So on the one hand, you've got that. But when things are filed before a judge in a divorce court, a family court, a custody court, just because it's written there doesn't mean that it's true. The judge understands that the lawyer puts these things in upon information and belief as told by his client. But the client may be lying. The client may be seeing things that, from his own perspective, from his own lens, which are not necessarily accurate. And the court knows this. And the court has heard all the lies and all the stories and all the he said, she said. The court's fully aware of it. So therefore, if somebody files something, the best thing to do is, if it's what we call something that demands a responsive pleading, like a complaint or a motion, you file a counter to it and you deny it. You say such and such is not true. That's all you have to say. You're not obligated to meet this parade of nonsense with your own parade of nonsense. You deny it. I've heard of lawyers who file motions to strike those things. I suppose one can do that. I think it's an utter waste of time. I think the court knows that certain things are alleged. If they can be proven before the court will react to it. If it's just words on a piece of paper, the court will not likely in any long-term way react to it. Okay? The court's ultimately going to want to hear testimony that supports it. Every now and then somebody will file something and the court will enter a temporary order based on what they read, based on an affidavit or something. But rest assured, if it turns out not to be the case, the court will rescind that order. So if you're worried about lies in the divorce papers, understand one thing. Just because somebody wrote something doesn't mean the court's going to regard it as gospel. The court is going to look at it and understand where it's coming from. It may be coming from someone who's not operating from a position of wanting to be as accurate and as honest with the court. It may be coming from someone who's operating under conditions of spite. They feel slighted, they're hurt, so they lash out and say something that's irresponsible and really not adhering to the facts. That happens all the time in family law. So I would tell you, just because you read something terrible about yourself doesn't mean that you should run and have your lawyer file motions to strike it or counter motions and stuff like that. Your lawyer should answer it. Your lawyer should say it's inaccurate and it's untrue and provide whatever documentation to refute it. I'll give you an example. I once got a complaint for divorce and we were representing the wife and the husband made an allegation that the wife is selling off all this marital property. Well, it wasn't true. She wasn't selling off anything. Those sales of those items had occurred 3 years before. But that's not what he told his lawyer. He told his lawyer, yeah, we had a house and she sold it. Yeah, we had this and she sold that. We had to rent the property. She went and sold it and she kept the money. So the lawyer immediately files a motion. But we denied it. And we came before the court and we showed the court the sales documents. And the court looked at them, looked at those documents, which we had provided to everybody. And the court said to the other attorney, have you seen this? This sale occurred 3 years ago. She didn't just do this now in anticipation of divorce. That was done a long time ago. If the money's still there, you'll get your piece. If not, not. And the court immediately rescinded its order. My point is that somebody calls you a name, so you call them a name. That's not how to win these cases. The way to win it is with proof. The court has heard all the mudslinging before. It doesn't resonate with the court much. What you've got to do is tell the court that it's wrong and explain to the court why it's wrong. Hopefully you'll be able to back it up with documentation and some evidence. If you have any questions about that, reach out and we'll be glad to help you out.